Companies Act, Section 470, Power to remove difficulties. Section 470 of the Companies Act, 2013 serves as an important transitional provision designed to empower the central government to intervene whenever any part of the Act encounters obstacles in practical implementation. Since the enactment of the Companies Act, 2013 represented a major legislative reform replacing the earlier Companies Act, 1956, it was anticipated that certain difficulties, ambiguities, or gaps might arise while shifting from the old statutory framework to the new one. To avoid disruption in corporate governance, compliance, and regulatory enforcement, this provision grants limited authority to the government to issue necessary orders to overcome such transitional challenges. 1. Authority of the central government to issue orders for removing difficulties. Under Section 470, if the central government feels that any provision of the Act is difficult to implement in its current form or creates uncertainty in interpretation, it may take corrective measures by issuing appropriate orders. These orders must be published in the Official Gazette, ensuring legal validity and transparency. Intended to remove operational or interpretational difficulties arising in giving proper effect to the provisions of the Act. However, this power comes with a vital limitation. The government cannot issue any order that is inconsistent with or that overrides the original provisions of the Act. The intent is solely to support the implementation of the Act, not to alter its legislative intent. Therefore, this power is considered facilitative and corrective, rather than legislative. It allows the government to make necessary adjustments during implementation without modifying the core provisions enacted by Parliament. 2. Time restriction on exercise of power. To maintain the supremacy of Parliament and prevent indefinite executive intervention, Section 470 includes a sunset clause. The power of the central government under this section can only be exercised within 5 years from the commencement of Section 1 of the Companies Act, 2013. After the expiry of this period, no orders for removing difficulties can be issued under this section. Once the time limit lapses, any further issues that arise must be addressed strictly through formal amendments passed by Parliament through the legislative process. This ensures that the provision remains a temporary tool to support the transition and does not become a long-term mechanism to change or clarify the law by executive action. 3. Legislative oversight through laying before Parliament. Democratic accountability is preserved as every order issued under this section must be placed before both houses of Parliament for review and scrutiny. This requirement ensures transparency in executive action, proper monitoring and control by the legislature, and assurance that the government does not exceed the boundaries of the Act. Thus, Section 470 creates a balance between giving administrative flexibility and maintaining legislative supremacy. 4. Purpose, significance, and benefits of Section 470. This provision plays a key supportive role in the implementation of the Act, especially during the early years of its enforcement. Its significance can be understood through the following objectives. Smooth transition helps facilitate the shift from the old Companies Act, 1956 to the new corporate legal framework. Quick resolution of practical issues allows the government to promptly fix operational obstacles without waiting for lengthy parliamentary procedures. Certainty in compliance reduces confusion or delays for companies and professionals during interpretation of new provisions. Legal and administrative continuity ensures that enforcement of the Act is not hindered due to transitional uncertainties. Checks and balances maintained, safeguards against excessive executive power by enforcing time restrictions and the requirement of parliamentary oversight. For more details, contact us.